Linda McClellan. I'm joined today by my colleague Emily Fidelis, as was mentioned. And I think that there's a lot of interest in this area right now, especially for software companies, but for all sorts of companies that do business on both sides of the Atlantic, and certainly for those who were participants in the old Safe Harbor framework that was invalidated at the end of last year and have been waiting for the quote-unquote replacement. We can advance to the next slide just to give a very quick overview of our practice. We have about 40 people on the team across the country that work on these privacy and data protection issues. Emily and I specifically work on data breach response, information governance, privacy and data security policies, and a lot on cross-border data protection issues and data security issues, a lot of addressing data protection concerns with respect to emerging technologies, and that often ends up being software type tech companies and their innovative products. And especially with particular relevance to today's presentation, we do cross-border data transfer issues. So next slide, please. We're going to just go through a quick agenda of what we're going to discuss today. First, Emily is going to lead off with a brief overview of how we got here, how we got to this new Privacy Shield framework. I'm sure many people on the call may be familiar already with the Schrems decision and Safe Harbor, but we'll just give a quick recap of what's happened in less than a year, actually. The decision came down last October, and there's been an enormous amount of activity since then. Then we'll provide an introduction to the Shield, some of the key components, give a little description of how it compares to the Safe Harbor. It's similar in some ways, it's different in some other key ways. Talk a bit about the viewpoints of regulators, both U.S. regulators and regulators in the European Union, with regard to how this is going to function to permit American companies and European companies that operate across the pond to transfer personal data from the EU to the United States. Talk a bit about the pros and cons of the Privacy Shield and whether it might be right for your company. It's not a no-brainer per se. For some companies, it's a more obvious decision than for others, but there are pluses and minuses, as with any kind of compliance mechanism. We're going to talk a bit about the enforcement landscape, or more appropriately, I should say, the projected enforcement landscape, since the Privacy Shield just opened for business on August 1st. So we don't even yet have anyone listed as officially having self-certified yet, but we have an indication of what's to come, and certainly within the text of the Privacy Shield itself, we know what is forecast and what has been contemplated by the framework in terms of enforcement. And then we're going to talk a bit about some of the uncertainties around the future of the Privacy Shield. There are certainly people who are concerned that it may also go the way of the Safe Harbor, and others that are very committed to making sure that doesn't happen, so we're going to go over that a bit. So if we'll advance to the next slide, Emily can give us a bit of an overview of how we got here.
Great, thank you. And to take it back a little bit, it's important to understand that there's a highly developed right to privacy in Europe. It's something that there's a strong emphasis on, and in wake of that, the Data Protection Directive of 1995 was passed, and is the first data privacy regulation that was binding on all EU member states. And essentially it regulates the process, or at the time regulated the processing of personal data, as well as putting restrictions on the transfer of personal data from EU to non-EU countries. And if you were a non-EU country receiving personal data, you had to provide an quote-unquote adequate level of protection. And it was determined that the United States did not provide an adequate level of protection under the directive. So the U.S. Department of Commerce and the European Commission worked together to create this Safe Harbor framework. And it was created in 2000, and essentially was a self-certification mechanism that allowed companies to lawfully transfer personal data from the EU to the U.S. after they self-certified and stated they would adhere to certain data protection principles and the like. And it seemed to work well at first, and approximately 4,500 companies or so certified under the Safe Harbor framework. And along the way, it seemed that perhaps there wasn't enough protection being offered, perhaps enforcement was not as strong as people in the EU would have liked. And then all of this sort of came to a head in 2013 when we had Edward Snowden revelation that the U.S. government accessed perhaps a lot more personal data and conducted a lot more surveillance than was known at the time. So these concerns, which had been building up to this point where Snowden made his revelations, kind of came to a head, and people started working behind the scenes to create a new mechanism to transfer data lawfully. Now, in the context of all this, in June 2014, we had Schrems case come along. So Max Schrems was an Austrian student who used Facebook, and he complained many, many times, actually, to the Irish Data Protection Authority that Facebook was unlawfully transferring his personal data from the Irish subsidiary in Ireland to the United States. And he was concerned that the U.S. could be unlawfully accessing his data. So eventually the Irish DPA responded and said, you know what, our hands are tied because Facebook has self-certified under the Safe Harbor framework, and there's nothing we can do. So Schrems appealed to the High Court, and eventually this went up to the Court of Justice at the EU, and that they laid down the Schrems case decision in October of 2015. So that is why we are here today. And essentially that decision invalidated the Safe Harbor framework. It went into some adequacy findings. It basically said that it's not protecting the fundamental rights of the EU data subjects with their right to privacy, and there was no effective legal protection for EU citizens. So in the wake of that, companies were sort of left in limbo. What do we do if we're a U.S. company trying to transfer data to and from the EU? So at that time, there were two, and there still are, two things that exist: binding corporate rules and model contract clauses, or standard contract clauses they're sometimes called, and companies could use those. The model contract clauses were more popular because for the binding corporate rules, first of all, it only applies to intra-organizational transfers, and second of all, it takes a while to get approved. So in that short time frame, companies couldn't necessarily enact them if they didn't already have them existing. In terms of the model contract clauses, it's important to note that currently, this summer, the Irish DPA has a complaint before her, again from Schrems, alleging that there's the same issues with the same defects of protection under them, and they have said that they plan to apply to the Irish High Court to determine the adequacy of those. So those right now may be a little bit in limbo. And again, in the wake of the Schrems case and the Safe Harbor being invalidated, we saw some interim enforcement by German regulators. We saw some fines. Essentially, 35 international companies based in Hamburg were investigated, and during that round of investigations, they determined that standard contractual clauses were enough. If you had those, your company would be considered, providing enough protection. And they actually fined 3 companies who said they were still relying on Safe Harbor, which had been invalidated, and they hadn't acted quickly enough to set up alternative legal channels for cross-border data transfer. So that's kind of the landscape that's leading up to the development of the Privacy Shield. Next slide, please. So while all that's going on, we had regulators saying, okay, hold on, no one panic. We're gonna work together to see what we can do to set the landscape right. So they had originally set an unofficial deadline of the end of January 2016 to come up with the new framework. They actually announced it in February 2nd, 2016, which is fairly spot on to that deadline, and they announced the Privacy Shield framework. And from then until it was adopted by the European Commission in July, there were multiple rounds of changes in the process. Some large edits were made, some small edits were made. Things were changing. The Article 29 Working Party opinion put out the Article 29 Working Party released a non-binding opinion in April, which sort of expressed some concerns on the level of protection and asked for further clarification on points. So at that point, we weren't really sure what was going to happen. Would it be scrapped? Would they start over? But they pressed on, and you see that it was officially adopted on July 12th. And again, in the interim, the United States was trying to put forth a good effort to show the EU that they were serious about providing protection, and that they passed the Judicial Redress Act in February. It essentially extended to non-U.S. citizens the right to sue the U.S. federal government under the Privacy Act of 1974 if they thought their personal information was being unlawfully disclosed. And it also gave non-U.S. citizens the right to access and correct U.S. government records about themselves. So a lot of the problems that or concerns that had been expressed in the Schrems case were sort of being addressed with this act. However, this only applied to citizens of EU countries, certain EU countries that were designated by the Attorney General, and there were some other limitations. Information must be shared with public or private entities with the U.S. government, etc. So it was a good start, but it wasn't enough. Next slide, please.
So now we're going to go through a bit of some of the key components of the Privacy Shield. So it's worth noting that, as mentioned in the last line of the previous slide, it was July 12th was when the final official approval came through, and the Privacy Shield was considered active and in force as of July 12th. However, because this is a coordinated effort between the United States and the European authorities, the Department of Commerce, the U.S. Department of Commerce, is actually in charge of running the certification process and some other enforcement elements that we'll get to in a moment. And so they had to set up the website through which you would do the self-certification. For those on the phone who didn't previously certify to the Safe Harbor framework, it was an online form that just it was relatively, and in terms of like the actual practicalities and the pragmatic aspects of self-certifying, was not that complicated. But the Department of Commerce has set up a whole new site, really user-friendly with all of the relevant details and information. It's going to contain a lot of information about companies that do certify and if any get kicked out. So they had to get all of that set up, and they announced that it would be open for business as of August 1st, and indeed it is now available. You can go on the site and self-certify. Up to today, as of today, I checked about an hour ago just to make sure, there aren't any companies that are listed yet, but ostensibly they're under review at this point. I know that Microsoft has a page up on its website saying that they comply with the Privacy Shield framework. They were early to come out in support of the Privacy Shield framework, so although they're not listed yet, I suppose that the assumption is that they will be soon. And my understanding is that other companies that have submitted their certifications are getting automated email responses saying that their applications are under review. So it is underway. So what are some of the key parts of it, some interesting points to consider? Like I said, it's about the same or similar self-certification process, but we have some more stringent data protection obligations. You've got the same privacy data protection principles that we would see under Safe Harbor: notice, choice, accountability for onward transfers, access to data, data security, data integrity, purpose limitation, and then recourse and enforcement and so forth. But they're going to be implemented a little bit differently. One of the key points is the limits on U.S. government access to data, or representations that the U.S. government has made regarding the reasons for which it may access European personal data and the specific circumstances under which that may occur. The representations on the U.S. government's part in this regard were very important because they needed to address the concerns that were issued or that were stated in the European Court of Justice's opinion that invalidated the Safe Harbor framework. Essentially, the drafters, the Commission, looking at coming up with its adequacy decision for this new Privacy Shield, had to make sure that it didn't suffer from any of the same defects as it ended up being the undoing of the Safe Harbor framework. Now, there are strong opinions on both sides at this point as to whether or not they have adequately addressed everything, but certainly they made efforts in that regard, and one part of that was some limits on the U.S. government's access to personal data of European residents. They've also added in some more robust enforcement opportunities and the ability for individual data subjects in the EU to complain or obtain redress for alleged violations. That was another thing that was seen as a deficiency in the Safe Harbor framework. In the invalidation of the adequacy decision, the court said, essentially there's no way for a data subject in the EU to do anything if they think that they're being violated or if a government company is doing something with their data. So now in the Privacy Shield, there's, first of all, a company would have to respond to direct complaints from individuals that have to respond to complaints that come in through data protection authorities in the EU, and there's an ombudsman within the U.S. government that's going to help handle complaints. There's an arbitration mechanism, and then there's also going to be an annual review process with the Department of Commerce and the European Commission and other interested parties to make sure that the Privacy Shield is operating as expected or to address any issues on an annual and ongoing basis. They're trying to address concerns about whether or not this is actually providing adequate protection for data, or if it was, as some thought, this safe harbor was too lenient or didn't have sufficient or robust enough enforcement mechanisms in place. Another key difference that I think is relevant to companies considering joining the Privacy Shield is if it so happens that at some point you are kicked out of the Privacy Shield, if you're found to be in violation and you're removed from the list, that's problematic in a PR sense because you will go up on the sort of name and shame list that's going to be on the Department of Commerce's website of companies that have been actually removed. But you'll also be required to destroy or return any data that you received while you were a member of the Privacy Shield. So, you could be going along for 2 or 3 years obtaining HR data or customer data from the EU and the United States, and then if you aren't actually adhering to the principles or living up to your obligations and you're kicked out of the program, you have to get rid of all of that data, and it could cause some significant operational concerns for companies to know what's going on. There's also some new data retention procedures, requirements about not keeping personal data of European residents for longer than the purpose for which it was collected, and if you had a reason to keep it longer, you have to get consent again from the data subject for that. This is general principle of EU privacy law, but it's specifically mentioned in this case, and then also have to put in place reasonable, appropriate measures to comply with these data retention requirements, and basically that's going to mean having an enforceable data retention and destruction policy within the company, which it goes hand in hand with having a good data security posture, but not all companies might, at this point, all companies might not have good procedures in place or might not have specific processes in place for disposing of EU personal data when it's no longer needed. There's a few exceptions to that rule, but in general, if you're collecting it just for HR purposes or for marketing purposes to customers or whatever, you're not going to have an unlimited or indefinite ability to retain the data. There's some record-keeping requirements as well. You're going to have evidence of your implementation of the Privacy Shield principles so that you could produce for authorities if they were to have to investigate your compliance, because they will have to investigate. That's another interesting point. If they receive credible complaints, or I suppose it's just not non-vexatious complaints about a company's practices, they'll have to look into them, and at that point you will need to be able to demonstrate that you've implemented the Privacy Shield principles and how you're complying. There's some training requirements for making sure that companies have appropriate measures in place, that their workforce is up to date. So in general, I think migration to the Privacy Shield, especially if you were in the safe harbor, might be pretty straightforward and just on a step-by-step basis, but in terms of actually complying and the potential consequences for not complying going forward, it might be quite another matter. We move to the next slide, and I've sort of covered some of these elements already, but some differences from the safe harbor, stronger data protection obligations and more specific requirements. The obligatory contracts for onward transfers is going to be something of a big deal. The onward transfer requirement under Safe Harbor was that you had to make sure that if you transferred data to any third party after you received it in the U.S., having come from the EU, you had to make sure that it was going to be protected. But now you have to have a contract in place in every case, whether or not the other party is also a member of the Privacy Shield, to ensure that there's appropriate protections in place. And transferring organizations, if you're transferring the data from the EU to the U.S., you can only do it for limited and specific purposes. It can't be just I'm transferring to this third party for them to do whatever they want. If the third party tells you that if your vendor or whatever is telling you that they're unable to continue to sufficiently protect that data, you're going to have to take steps to actually remediate that, to get back the data or to end the unauthorized processing. And you may have to provide a summary representative copy of the actual privacy representations, the contract provisions from these contracts with third parties. That's new as well, that you would have to come out and say, okay, well, here are my vendor contracts. These are the provisions that I've put in place, and this is what they're supposed to be adhering to. The Privacy Shield is much more, has a greater deal of emphasis on the fact that organizations are liable for their agents' failure, or any actually onward transfer, the failure of any third party to whom they transfer data, if that entity fails to comply with the Privacy Shield principles. So in theory, a company was going to be on the hook if there was a problem in the past with an onward transfer, but it's much more explicit in this Privacy Shield framework. Like I mentioned in the previous slide, we've got some new complaint and redress mechanisms and this annual joint review process for reassessing the program, and we'll talk a little bit more about what was already been said about that annual review process. But another point I think is that we'll likely see more enforcement. It's not certain, and we haven't had any examples yet, but given the concern with the safe harbor being that it wasn't sufficiently enforced, and there were enforcement actions. The Federal Trade Commission did bring enforcement actions against companies, specifically companies that either said that they had certified to the safe harbor, they weren't really certified, or they said they'd renewed their certification, but it hadn't actually been renewed. They did do some enforcement actions, but it was on the order of a few dozen enforcement actions with, as Emily mentioned, some 4,500 companies that were in the safe harbor. So that was a concern all along, and I think that moving forward under this new Privacy Shield framework, especially in this beginning time, this first year or two, it's going to be incumbent upon the U.S. authorities to make sure that they are demonstrating a willingness to enforce against companies that aren't living up to their Privacy Shield obligations. I mean, certainly we hope that every company lives up to every one of its representations and is doing everything that it's supposed to be doing, but realistically, depending on how many companies sign up, there's likely to be some violations or even just some questionable practices. And so not only is there an incentive on the part of the U.S. authorities to show that there's a real commitment on this side of the Atlantic to enforce this new framework to help U.S. businesses be able to continue to do business across the Atlantic, but there's also new affirmative obligations on the U.S. authorities to investigate complaints, whereas previously the Department of Commerce ran the website and could have looked into something. Now there's an actual affirmative obligation for them to investigate credible complaints that wasn't there before, and it will be interesting to see how that plays out in terms of, what will constitute a complaint that requires investigation, and how will they go about looking into that. And they will be the Department of Commerce will be working in consultation with the EU data protection authorities as appropriate to do these things. So there's going to be a lot of coordination. At least that's the idea behind it. There'll be a lot of coordination across the pond to make sure that this is working as intended. So we'll move on to the next slide, and Emily will talk about one of the sort of important requirements that companies will have to be considering almost immediately if they want to join the Privacy Shield.
So that requirement is the requirement of notice. So previously under the safe harbor, there was a notice principle, but it was a lot less involved than what we see in the Privacy Shield. The notice principle under safe harbor said that organizations must notify individuals about the purposes for which they collect and use information about them. They must provide information about how individuals can contact the organization with any inquiries or complaints, the types of third parties to which it discloses the information, and the choices and means the organization offers for limiting its use and disclosure. So sort of broad sweeping language, you need to do these things, but we're going to leave it up to you in terms of how you do that. We do not see that under the Privacy Shield. We have many more specific requirements. You can see them listed on the slide here, and the couple that we think are really important to highlight are in red. First, the right of individuals to access their personal data. This always existed, but now it needs to be clearly spelled out in your privacy policy, and it's, no questions asked. Everyone needs to know that this is something they can do. The designated independent dispute resolution body. We never saw this before. This is brand new. This is something that there was a concern about, as we said, the enforcement under the safe harbor, and we were trying to eradicate that under the Privacy Shield by providing this independent body that can solve disputes if there's an allegation that personal data is being used improperly or transferred improperly or something along those lines. We also see that an individual may, under certain circumstances, be able to invoke binding arbitration. It's kind of a crazy thing if you think about one individual perhaps sitting across the pond able to bring a multinational company to an arbitration setting because they feel that their data isn't protected or that the company is not following the Privacy Shield. So that's definitely something to be aware of from an organizational standpoint. And finally, it's the organization's liability in cases of onward transfers to third parties. Now, again, this existed, but now they have to say it. They specifically have to spell it out. And it's important to understand that this doesn't just apply to an affiliate or a subsidiary. It's any onward transfer that this data, for any reason, might be going to any organization. So those are really important things as an organization if you're considering certifying under the Privacy Shield that you have to be aware of. Next slide, please. And we've talked a lot about the Privacy Shield and what it is and what it means, and we're going to break down the pros and cons a little bit. Obviously, one of the pros is that there are some complications using binding corporate rules or using standard contractual clauses or model contract clauses. They aren't applicable in every circumstance. For example, binding corporate rules are only intra-organizational transatlantic transfers, so that may not apply to your organization or to every organization, and they're definitely more labor-intensive than the Privacy Shield. And also the standard contractual clauses, you have to enter kind of into a contract in every situation to be able to transfer data. So with the Privacy Shield, you're hopefully able to avoid that by self-certifying in this way. Also, the idea is the Privacy Shield would provide greater predictability with respect to your obligations and the enforcement. Now, again, as Melinda said, we haven't seen any enforcement yet because this is still so new. We're not even 2 weeks in yet. But the idea is everything's spelled out in a clear manner, and your requirements are very clearly the requirements are very clearly communicated to the organization, and that the enforcement will follow in a clear manner as well. And if you've already self-certified under the safe harbor, the non-existent safe harbor, but while it existed, if you self-certified, you already have a pretty solid foundation you can expand your privacy policy and expand your programs in your organization to cover more of, to be compliant under the Privacy Shield. So those are some of the pros, and Melinda's going to talk about the cons now.
Right, so we can move to the next slide. So, we've alluded to some of these before, but one of the cons that's just generally applicable with this particular kind of program, as with the safe harbor, is that it only applies to data transfers coming from the EU and going to the United States. It doesn't apply to, say, if you're transferring data from France to South Africa or from Germany to Japan or any of those other kinds of transfers. This is just an EU-US situation. And it's only available to companies that are subject to the jurisdiction of either the Federal Trade Commission, the Department of Transportation, or certain other U.S. government authorities. So it's not a blanket, you can just certify and now you can just send data wherever. It's really only for EU to U.S. transfers and only for companies that are subject to the jurisdiction of those entities. For example, financial institutions aren't subject to or directly subject to the jurisdiction of the FTC and wouldn't be eligible for the Privacy Shield. So there's some limitation to it. It involves this publicly assuming a lot of obligations that could be enforced by U.S. regulators. So what we've seen just in general, if you talk about privacy data security law, is that the Federal Trade Commission has stepped in and will look at your online privacy policy as affirmative representations that you're making to the public about what you do with their personal data. So, when you hear of a high-profile data breach situation, often the FTC goes back, and state attorneys general to some extent, and definitely plaintiffs' attorneys, go back and look at the privacy policy that's posted on the website, and if it says something like, well, we secure your data, 100%, or we guarantee your data secure, we'll never sell your data, and then it turns out that wasn't true. It's treated as a deceptive trade practice because assumedly the individuals who provided their personal data thought that policy would apply to it, and you didn't honor the commitments in that policy. So along those same lines, as Emily was going through the list of notice requirements that will have to be in any notice that's provided to EU data subjects whose data you're going to be collecting, but prominently you'll have to be on your website, you're going to have to make all these representations that then could be enforceable by regulatory authorities. And any, regardless of the circumstance, anytime you're making those kinds of enforceable representations, you're assuming a certain amount of liability for making sure that you adhere to them. This is not a secret back of the room deal that you're making to transfer data. You're making public representations that could be held against you if you fail to live up to them. As I mentioned a couple slides back, if you're expelled from the program, then you have to get rid of all the personal data that you already collected. And it's hard for me to imagine, pragmatically or from thinking about clients that I've worked with who were in the safe harbor are looking to do this, how organizationally or bureaucratically difficult it would be to do that, how you would maybe lose an entire customer database or a lot of employee information, how you would get it back to your U.S. Subsidiaries or the U.S. headquarters, if that's the case, from the EU after that point. Logistically, it could be something of a nightmare. So it's not saying don't join the Privacy Shield, but be aware that if you don't live up to what you said and you end up getting kicked out, there could be quite a bit of fallout from that, not just that you would be listed as having been kicked out and you might be in breach of contract in certain situations, but that you would have to actually get rid of that data. And if you leave voluntarily from the Privacy Shield, if you just decide a few years on, maybe there's a new data transfer mechanism, maybe you decide to do binding corporate rules that Emily discussed earlier, you decide that's the right thing for your organization and you just no longer wish to be a part of the Privacy Shield, you'll have to continue to certify on an annual basis that you're adhering to the Privacy Shield principles with respect to the data that you did collect while you were under the Privacy Shield. So this is not just going to die because you decide not to renew anymore. And the Department of Commerce will check in with you to make sure you're doing this. If you don't want to do that, then again, you're back to you have to get rid of the data. So if you accept data from the EU and the United States under the Privacy Shield, you are responsible for adhering to those Privacy Shield principles with respect to that data forever, basically, and you will be checked in on that. So it's just something to consider before leaping in. You're going to have to respond to access, amendment, deletion requests from EU data subjects. This like, as with what Emily was discussing just a minute ago, this has kind of always been, it's a general right of EU data subjects under EU data protection law, but it hasn't been, to my knowledge, as much of an issue for companies. Companies haven't been receiving so many requests to have to do this, and it's something that EU companies are perhaps familiar with having procedures in place, but U.S. companies maybe less so, and they'll have to consider that. And another potential downside is that we've already had certain European authorities, data protection authorities and other government regulators expressing skepticism about whether or not the Privacy Shield is going to pass muster, if it's going to actually work the way they think it's going to work, whether or not it actually does provide adequacy as required under EU data protection law. And so we'll talk in a little bit about the future of the Privacy Shield and whether that's going to become a concern, but it's something to consider. And then another twist with the Privacy Shield that wasn't at least specifically laid out under Safe Harbor was that if you're investigated by the FTC for Privacy Shield violation and you become subject to a court order or noncompliance order or agreement with the settlement agreement with the FTC about this, you're going to be required to make public any Privacy Shield related sections of the compliance or assessment report that you had to submit to the FTC. So the FTC comes in to investigate your Privacy Shield practices. They ask you for compliance assessment reports, things like that, to verify your compliance mechanisms. Maybe they determine they're inadequate and they're inadequate and you're subject to a court order. Then you're going to have to make the things that you disclose to the FTC public. And those kinds of compliance reports, that are demanded by the FTC in those kinds of investigations could become public and could be problematic from a litigation standpoint if you have plaintiffs' lawyers who are interested in using that against you as well. So you can go to the next slide. start talking about a little bit of practical advice. Let's say that you have decided, you've gone through the process within the organization, you know that you want to join the Privacy Shield. What should you do? So one of the first things to get in order is your online privacy policy to cover those new requirements that we discussed a few slides back. And it's not as simple as just taking them and transposing them into your policy, because you want to make sure that you cover exactly what needs to be covered, but express it in an understandable manner and in a manner that you can comply with. So, and also right now, if right now you still have references to the safe harbor in your privacy policy, those need to be removed because it's invalidated and it's essentially defunct. It kind of is a bit of a flag to a regulator that you haven't been perhaps paying attention so closely. If you do not have, if you're still saying on your online privacy policy, we are compliant with the safe harbor framework and we use the safe harbor framework to transfer data, that's problematic. The next big step, and it depends on your organization as to whether or not this is going to be a very labor-intensive process, is reviewing your third-party vendor agreements for these onward transfers that we were referring to. You have to look and see which one of your vendors, find out all of the vendors that you have that receive EU personal data, and then put the appropriate contract provisions in place with them to make sure that they can continue to do so lawfully once you're certified as part of the Privacy Shield. And then you're also going to have to verify that they're complying. It's not good enough to just say, here, sign this, and then forget about it. You're going to have to follow up because, as we stated earlier, you will be liable for their failure to adhere to their obligations in that regard. So to really quickly, something that you may have heard of is that there's this sort of early bird deadline for companies that register quickly or early to qualify for a 9-month grace period concerning their onward transfer. So when we're talking about these third-party onward transfer agreements, if the way that the language is in the actual documentation is that if you self-certify to the Privacy Shield within the first 2 months of its operation, then you have 9 months to get your onward transfer agreements in place. So as I said earlier, the Privacy Shield became effective the day that decision came down, so July 12th. So many people are saying that September 12th would be the 2 months cutoff. Others seem to be interpreting it as the end of September because it doesn't say the day of. But regardless, it's upon us very shortly. And if you want to qualify for this 9-month grace period to get your onward transfer agreements in place, then you would want to self-certify by that deadline. Now, if you don't do that, you'll still be able to self-certify, of course. It's just that you'll need to have all of your onward transfer agreements in place. You'll have to have already done all of this renegotiation or getting new contract writers or provisions in place with all of your third-party vendors before you certify. So, there's pluses and minuses to being an early joiner, and we'll discuss those a little bit more in a minute. But that is something that's coming up that you should be aware of on a practical level. And then also you're going to have to update your internal policies and procedures to reflect all of these new requirements that you're subject to, especially the data retention and disposal requirements. Maybe some companies already have those totally covered. Others that don't will have to maybe bulk them up or add new provisions with respect to EU personal data specifically. You'll want to bolster your training documents, make sure that your employees are going to understand what their obligations are under the Privacy Shield. You wouldn't want an inadvertent problem. I mean, there's a lot of American or U.S.-based employees who simply aren't aware of EU data privacy law requirements or might not have any idea that the legal department or whomever within the organization has decided to certify to the Privacy Shield and has thus taken on a variety of obligations with respect to EU personal data. This would include HR employees if you're receiving HR data from the EU, but could be employees in a variety of different departments or anywhere across the organization who might end up touching that data and having obligations with respect to that data. And then also need to prepare to document your implementation and compliance steps, because that's a new requirement that you have to have documentation of how you implemented your compliance. So you could I suppose put that together at the end, but it's probably an easier and more fluid process if you're doing it as you're going along. We cataloged all of our third-party vendor contracts. We determined these are the ones that transferred data or received data from the EU from us. We went through this process, that sort of thing. So getting ready to do that is going to be an important part of gearing up to self-certify to the Shield. So move to the next slide, and Emily's got a few more details.
So if you decide you do want to self-certify, you go to the privacyshield.gov website. And again, as we mentioned before, if you are already certified under the Safe Harbor, that's a strong starting point. You should have a lot of this information already gathered or know where to find it. If you had not previously certified under Safe Harbor, it's a good opportunity to get people in the room to discuss, how we're going to comply with this Privacy Shield and get this information together. On the website, it encourages you to compile all of this relevant information before you sit down to certify, so you can speed up the process when you do it. What you need to gather includes the organization's contact point. And a note here, it seems like this might be a pretty easy thing. Just designate someone to be the point of contact for handling any complaints or any access requirements, any other issues that the organization might need to worry about when complying with the framework. But it's really important that if you decide to self-certify, that you designate someone as the contact point who not only is able to ensure compliance internally, but kind of take the wheel and steer the program. And sometimes it can take a while for an organization to get all their ducks in a row and to sort of have everything lined up to comply before they self-certify or before they do something like this. So it's important to not just jump into this. Think about how your organization will implement all these steps, will actually be able to comply with the requirements under the Privacy Shield. And another important note on this point is that if this person leaves the organization, it's important that you update, you create a new contact person, and also make sure that is conveyed to the appropriate people under the Privacy Shield, because that's something that you can kind of do on autopilot. Sometimes if you have a program running within your organization, it can be easy to just kind of let it be. But as we've discussed, we do believe there'll be some robust enforcement of the Privacy Shield, so it's important not to overlook that. So in addition to a contact point, you also need a corporate officer who will submit the form, essentially attesting that he or she is authorized to submit this self-certification on behalf of the company. You need to describe your activities with respect to cross-border transfer, also lay forth the independent recourse mechanism that you'll use to investigate any unresolved complaints, describe your privacy policy, and you also need to list your organization's annual revenue. And that's important because that is tied to the annual fee that you'll pay to self-certify. So like the Safe Harbor mechanism, which there was a certification fee as well, the Privacy Shield has one, and if your annual revenue is under $5 million, you'll pay $250. And there's sort of increments going up to, if you make over $5 billion, you'll pay $3,250. So once you've gathered all this information and you go to the website, you can just basically click the self-certify link, and you'll submit your information, and you'll be required to pay this certification fee. But unlike the Safe Harbor, under the Privacy Shield, there'll be additional direct costs associated with participating in the Privacy Shield. So they haven't figured out the actual fees yet, but by January 2017, the Department of Commerce and the European Commission expect to set the amount of the annual contribution that organizations must pay. And part of that will go to the arbitration costs. As we've described, there has to be an arbitrator available to resolve disputes if it gets to that. And as some of us know, arbitration is not cheap. So all organizations will be paying into that fund. Also, we've talked about the independent recourse mechanism to hear individual complaints, and that has to come at no cost to the individual. So the EU citizen will not be, or whoever's complaining about the data will not be the one footing that bill. So that will be on the organization that has self-certified under the Privacy Shield, and that would just be at the discretion of whatever service that organization used. So they'll be setting their own fees, and it'll be up to the organization to set the bill. So it's just important to know that there's a lot of information to gather before you self-certify, and you really need to make sure that the program is able to be implemented within your organization before you just jump into self-certification. Next slide, please.
So I want to talk briefly about the enforcement landscape. We've kind of touched on this throughout the presentation, but since one of the big questions and problems that many EU authorities, regulators, people had with the safe harbor was that it wasn't being enforced properly, or that there wasn't enough there was no recourse for EU data subjects and so forth. The enforcement landscape is going to be kind of important here. Now, as I mentioned earlier, from the commercial sector side, that you're making these public representations about what you're doing in terms of data protection, and that may increase the potential liability. So there could be, third-party plaintiffs, lawyers type issues in terms of representations you've made if you're not able to live up to them. But that's just one element of it. In terms of what the U.S. government's able to do, this is the first time that we have specific written assurances from the U.S. government that the access by public authorities of this personal data is going to be subject to certain limitations and safeguards and oversight. And so if there's a question about whether or not they're actually doing that, it'll be interesting to see how questions about that are pursued. They've come up with this ombudsperson role. That has to be the individuals have to be independent from the intelligence community in the United States, and they're supposed to be handling and resolving complaints from individuals about how the U.S. government is maybe obtaining or accessing personal data that they shouldn't. So that we're kind of in uncharted waters in terms of how that's going to play out, but it'll be something to watch once this gets underway. There's several different avenues for EU data subjects to pursue remedies for violations. It's actually spelled out pretty clearly in the Privacy Shield documentation, the path that the individual has to take if they have an issue. But to start off, they directly can address the company and say, I have a problem, like your data on me is inaccurate and I want you to fix it, or I don't want you to transfer this kind of data, or I don't want you to use it for marketing purposes, things like that they would address directly to the company. And the company is going to be required to reply to complaints from individuals within 45 days. Which sounds like a fair margin of time, but you can imagine, like, if a complaint is directed or misdirected within the organization, doesn't get to the right person until the right time, we could have some real problems there. Then they can go on to the alternative dispute resolution mechanism that has to be available to individuals free of charge, and then the EU authorities and U.S. authorities may intervene to assist, and there's also going to be a Privacy Shield panel arbitration mechanism. And then in terms of monitoring, we already kind of covered this, but the Commerce Department, the Federal Trade Commission are going to be monitoring compliance and vetting applications and making sure that doing ongoing audits to make sure companies are living up to that. And then there'll be the annual joint review mechanism with the European authorities to make sure that the Shield itself is operating as intended, and ostensibly possibly to update it. So through the next Shield, Emily's going to talk. The next slide, Emily's going to talk briefly about how that might play out.
So with the implementation of the GDPR, we're obviously not quite sure yet what the interplay is going to be, and people believe, experts believe that something will happen, but we're not really sure. So we're just going to see how everything plays out. The GDPR will take effect in May of 2018, and an important thing to consider is that that Privacy Shield provides adequate protection for personal data under the current directive, which will expire in May 2018 when the GDPR takes effect. So there's some question as to whether this adequate protection will stand under the GDPR, and it's possible that it will not. It's also possible that prior to this expiration in May 2018, that the adequacy will be subjected to a legal challenge. Now, the Article 29 Working Party has already announced that the EU data protection regulators will not challenge the adequacy of the Privacy Shield until basically a year from now, until after summer 2017. So we have the annual review mechanism of the Privacy Shield, and Article 29 Working Party has said, all right, we're going to give it a year, see how it plays out, and we won't challenge it before that. However, they're not the only individuals, or they may not be the only individuals who are capable of challenging this Privacy Shield, and we've actually already seen from the DPAs in Hamburg, Germany, that they've expressed that they want to challenge the Privacy Shield, and they're currently waiting to see if German law is going to be changed to allow them to basically take the steps to get a ruling on the validity of the Commission's decision as to the adequacy. They've expressed that their doubts, they have their doubts as to whether the adequacy decision meets the legal requirements of the principles of proportionality and the judicial redress. So there is a decent chance that this will be challenged in court. So we'll just have to see how that plays out.
I'll just jump in real quick and say there's one interesting thing in the actual adequacy decision for the Privacy Shield. It says that the Commission has determined that the United States ensures an adequate level of protection for personal data transferred from the European Union to these organizations under the Privacy Shield. The language in the adequacy decision for the safe harbor was different. They found that the safe harbor principles, the safe harbor privacy principles, and the other implementing documents ensured an adequate level of protection for personal data. Now, I've spoken to different EU lawyers who are not entirely sure what the difference will be in terms of legal challenges, but it's certainly a different legal approach. The Privacy Shield is not the actual adequate instrument in this adequacy decision. It's that the United States is now adequate for organizations that are using the Privacy Shield, as opposed to the Privacy Shield itself being deemed adequate. So I'm sure that was not a drafting accident. We'll have to see what the actual implications of it are. And if we go to the next slide.
And another potential effect or potential kind of wait and see what happens is the effect of the Brexit on the Privacy Shield. And of course, the referendum was on June 23rd that, the Brexit is happening. And about 2 weeks after that, the ICO in the UK actually released GDPR guidance. So after the Brexit had already been voted on, despite the results, they basically said that the government needs to consider the impact of the GDPR on UK law, but they still thought it was useful to publish the overview because of the changes that have been going on. They've said the Data Protection Act of 1998 remains law of the land in the UK, but they're going to need to reform it to maintain trade relations with the EU. So we're not sure. It depends on how the UK, what the status of the UK is as it leaves the EU. Will it be an EEA member? Will it be an independent country? Will they essentially pass the equivalent of a GDPR? Will they try to create a separate EU-UK privacy shield? So we're not sure how that's going to play out, and a lot of that depends on what Britain's status will be after the Brexit takes effect in 2018 or 2019. But for purposes of organizations within the UK, they're still going to certainly have to do something to be able to maintain relations with the EU.
So I think that brings us to the end of the presentation. If you advance the slide, I know everyone's going to get a copy of the deck. If people have follow-up questions, please feel free to reach out to us. And thank you for joining.
Thank you very much.
Melinda, Emily, that was fantastic. This certainly has a huge impact on software companies and our industry, and there's a lot of information here, and I think that's very helpful for companies to have. And certainly they're all going to need some help probably navigating this and which way they should go. We are just after the top of the hour, so I want to be very conscious of everybody's time and calendars, and thank everybody for joining us today. We're going to go ahead and take questions offline just because of the time, and certainly I know that some of the questions that you all probably have, Melinda and Emily can go into much greater detail, and so again, want to be conscious of everybody's time, so we will take those offline. Again, please thank you, Emily and Melinda. We certainly appreciate your time today and all the information that you have provided. Their contact details are right there on the screen. Feel free to reach out to them directly. You can also reach out to me directly if you want, and I'd be happy to make sure you get connected. And again, we'll get those questions answered. So thank you, everyone. Have a great day.